Hello and welcome to BloombergQuint. I'm Navneet Saluja D'Souza. Well, the market regulator has barred one of the country's largest brokerage houses, that's Karvy Stockbroking, from taking on new clients. The broking firm has allegedly moved client shares into its own account via off-market deals, misusing power of attorney given by its clients. A forensic audit has now been commissioned by National Stock Exchange. But what implications will this order have on clients of Karvy whose shares have actually been pledged? How do they recover their money? And is there any mechanism now that provides for some compensation in case of such an unsanctioned transfer? Joining us now to talk about it is Anuj, Shah, Director at Tracom Stockbroking, and also Gupta, Founder and Managing Director of Stakeholders Empowerment Services. And also joining me on this conversation is Sajit Mangat. Let me begin this conversation with Anuj. Hi, Anuj, and thanks a lot for joining us. I think I think Mr. Gupta is right now with us. Mr. Gupta, the big question is what happens to existing clients who have Demat account, of course, with Karvy, and their shares have been misappropriated by the broking house. What options do they have now ahead of them?
See, it's very difficult now to say what will happen because it will be case by case, client by client issue, because it cannot be a general issue. It depends upon what type of relationship was there, how many shares have been transferred, and what is the money available. The very simple thing is this: the Karvy has been prohibited from taking new clients, but existing client things continue, they remain the client of thing. However, given the situation now where the Karvy has been found to be misusing client money and shares or misappropriating them, then it is very simple that existing clients will also think 10 times before continuing their relationship with Karvy. And again, the issue is this: a question would come whether investor protection fund will be able to be used for this thing or not. I have my own doubts for the simple reason: investor protection fund is supposed to be used for all those trading done on the stock exchange platform and all other things. In this case, it is not something which has happened on the stock exchange platform. It is off market and based on certain dealing or certain agreement which we are not aware. But logically speaking, it is not possible or should not have been done, because given the fact that the relationship between a client and broker is not of a situation that the client has transferred the property right in its equity or money to broker. It is only a service trustee or some sort of fiduciary relationship where they have to protect the client fund. It is not that you commingle your fund and other client fund and treat it as a common pool. That's not there. And SEBI circular in 2019 June has very clearly asked them to segregate, and it is probably that circular and the data analysis of SEBI which has revealed all these things.
Okay. We've got Anuj Shah also joining us. Anuj, hi. Do you feel then there are a lot of retail clients who have accounts with Karvy? They're concerned now if they would have initiated any sort of trade either on Thursday or on Friday, considering we are working on T+2 mechanism. Can Karvy prevent any sort of settlement now on clients' behalf?
Hi. See, regarding the point regarding settlement of client securities that have been sold either on Thursday or on Friday, if we go through the interim SEBI order, what it says is that the intermediary has been banned from taking on new clients. The depositories have been requested to monitor the movement of funds, and new instructions based on the power of attorney that the intermediary has with the clients have been banned. I am sure there is no further detail regarding the settlement that was there on the past. This order is for the new thing, so there should be logically no problem for the settlement that has gone through on Thursday and Friday. The paying will happen in consultation with the depositories.
Anuj, while this thing has been monitored by by the market regulator and the NSE, what are the rights of the retail investor in case they have an account with Karvy?
See, now there are two aspects to it. There would be one set of retail investors who have their broking and depository operations with this particular in Karvy, and who are not affected. That means either their shares were not misappropriated or there was nothing wrong that happened in their account. And there is another set of clients with whom there is something wrong that has happened, that is their shares have been misappropriated. Now, for the first set of clients, they are at liberty to shift either their depository operations or their trading operations to any other intermediary of their choice. In case where a client finds that there is something wrong that has happened with his shares, then he has to go through the process of filing a complaint with the necessary exchanges and the regulator, and then the law would take its own course.
So you mean to say they have to go to the investor services cell of the stock exchange and then file a complaint. We had Mr. Gupta saying that in this case there may be a case that the investor protection fund may not be able to help them because this is not a transaction that happened on the platform, but it's an off-market transaction where brokers, Karvy, may have taken the securities or money from the pool account and used it for purposes other than the client's need. In such a case, what is the recourse that is available to investors?
See, now this entire matter, whether the loss that is caused to the client because of this, I would say unappropriate action by the intermediary, whether the investor protection fund will be used to reimburse the investor or not, is a matter of interpretation. But one thing is very clear, that the intermediary has not used he has not used the right that the client has given him through a POA appropriately. Now it is a very common phenomenon that the client gives a power of attorney to his intermediary that has only and only to be used for meeting his obligation. Unfortunately, in this case, the intermediary, it seems, has not used this power appropriately. Now, whether the investor protection for this case is called or not, or whether he has used for any other purpose other than what is there on the exchange, will be a matter left to interpretation.
Mr. Gupta, do you think it's safe to assume that existing clients whose shares so far have not been touched and who have, of course, demat account with Karvy, they do not stand to lose anything with this order, and now they have an option to shift their demat account to some other broking house?
Yeah, obviously, because if a client's account remains intact, it has not been misused, his security are there in his account, he is free to move his account from Karvy to any other place, or he can still trade with Karvy and transfer the security. There is no problem. There is no prohibition on the client per se. The clients are free to do what they are entitled to do. It will be the problem only in case that there is a client and who had security with Karvy, but Karvy has misappropriated the security or money. Those clients will be the people who will be suffering, who will of course have a recourse. They will recourse against the Karvy and they will be able to file a complaint. And again, it will depend upon how the regulator views it, whether a part of it is compensated by IEPF or it has to be usurped out of the total money that is available with the Karvy. It's a matter which will be taken in due course of time, but none can say today that what will be the value and how much they will be able to recoup. No one knows.
But as per your experience, Mr. Gupta, what sort of legal recourse can a client take? Because even if the client was trading in the derivatives market, you sometimes tend to give your securities as margin requirement. And if those securities are not available, exchange automatically squares off that position.
No, but again I say the issue is very simple. If I have given my securities for margin trading and it has been used only for my margin trading, I have no recourse against Karvy. It is my loss. But in case my security has been used for margin trading by some other person, then I am at a loss because I have not taken action and I have not done a trade or something like that. But still my money has been used, my security has been used for a third party. So in that case, I will be suffering. So it will again be done on a case by cases because the Karvy has got a huge number of clients. It will be each and every case has to be examined. What is the misappropriation? What is the extent of misappropriation? And if the problem is that happened is this, that Karvy has used every client's margin money, margin securities and all other securities as a pool of securities available for its either its own thing or for margin trading of other investors. Whereas it has to be person A's margin trading has to be done by person A's securities or person A's money or Karvy's own money. Karvy cannot use client B's money for person A.
Mr. Gupta, there is a view in the market that this entire case also makes a case to make some changes in the way clearing of securities and money happens for especially for retail and HNIs, because from the institution point of view they have a custodians who are undertaking all this process, but for retail investors they go through clearing members and trading members to do this process. Should now there be a case that okay, we need to get that same custodian mechanism here for retail investors as well?
See, it will be impractical for retail investor to appoint a custodian. However, if you go into the background, you will say that every time there is a hue and cry that there is a seamless trading is not available to retail investors. So in order to do that, SEBI had permitted brokers also to become depository participants so that the seamless operation could be done. So it was an exercise for the ease of business. But what has happened, unfortunately, in our country, a facility that is given, although it benefits many, but it harms many other also. So it is one of the harm that has happened where the broker had everything in his own hand. Depository account of the client was also be operated, bank account was operated, securities account was operated, trading account was operated. So everything was just one person. So as a result, the seamless trading became a nightmare for all those people who have lost out. So SEBI will have to, again, a facility which has been going on for long and which has benefited millions of people cannot be stopped midway. So SEBI will have to really do an exercise that what additional safeguards can be brought in and whether it needs to be reviewed or cancelled or not, one has to see. But I would say that ultimately at the end of the day, whatever regulations regulators make, unless until the client themselves are aware or client themselves monitor, because if you see every bank account of the client, if you have a savings account or you have a credit card account, you monitor your transaction. Why don't you do the same thing for the securities account? Why don't you do with the trading account? The problem is this, we become relaxed and we feel that, oh, somebody is taking care of us. But that time proves to be a nightmare.
Is there any enough checks and balances in the system, as Mr. Gupta is saying that if there is any transaction that's happening from your account or your shares have been moved to a pool account or from a pool account to somewhere else, or the money hasn't come in, is there a checks and balances for the investors to know that there is such movement of securities or money happening from their account? Anuj?
Yeah. See, regarding what you said, the regulator has since a very long time introduced many measures which makes the client aware of any movement that happens from either his demat account or from his trading account. The KYC form that the client fills up and gives it to his intermediary, the investor must definitely mention his mobile number, his email ID, and the same are uploaded to the exchanges. Any trade that happens, apart from the fact that the intermediary also sends an SMS or an email to the client, the exchanges also send an intimation. So that is a double check that the investor can have. Also, the depository sends details and alerts about movements that happens in his demat account. Unfortunately, not many people take advantage of the same, and as Mr. Gupta said very correctly, that most investors tend to get complacent about the fact that these checks are available and they don't use that. It is now the duty of all intermediaries, all regulators and all exchanges, and they have been doing this since a long time, of making investors aware that there are these steps available and they should make full use of the same.
Mr. Gupta, do you think there could be other brokers as well who have not complied with returning client funds or shares?
See, I would not look into this and I will not do crystal gazing. I would not say anything on that. But as if you see, the Karvy has given a clarification that it is an industry-wide practice and it is a standard procedure. If that is true, then obviously there would be many cases where the client's securities, client's money have been used as a pool account of the broker. I would not know, but there is a likelihood that there could be some more cases.
Mr. Gupta, SEBI has come out with guidelines with respect to pool accounts, especially client money and securities, where pool all the brokers were supposed to unwind all the pool accounts and only keep the client accounts in place. Also, the only thing that they can keep is either if it's an unpaid account or if it's a margin account, then only the client securities can or money can be kept in those accounts. So while all those regulations have been put in place this year as well, why is it difficult for brokers to adhere to these these regulations?
See, again, the issue is very simple, that if everybody was compliant, everybody was honest, everybody was following the law, or not even law, what everybody was following what is the ethical conduct required, neither there will be need for policemen, nor judges, nor regulator, nothing. The issue is, even without SEBI's regulation, one has to go to the basic. If I give you my money, if I give you my share, I am giving you as a broker. You cannot become owner. The moment you think that you're owner of those securities or money, then you're right from day one you are wrong. SEBI doesn't have to even tell you this. The issue is people are not following it. That's why SEBI has to come to this regulation or circular. So the issue is very clearly, you brokers have failed in their fiduciary duty.
Mr. Gupta, the option now ahead of Karvy is, of course, they've got 21 days to reply to the SEBI order, and it's ex-parte order, it's just temporary. Let's say if they are actually found guilty of what is stated now in the order, what sort of measures can a regulator take against a broking house?
See, there are a couple of things. First is very simply the regulator's focus would be to minimize the impact of this on investors and system. So to take care of the system, they have already passed an interim order where Karvy has been barred from taking new things. This order again will make all the Karvy clients to sit up and see what position of their account. Based on that, all and full investigation and forensic audit that is happening, the regulator would be able to find what is the total quantum of misappropriation and where this money is lying and where the securities are lying, and what will be required to unwind all this position, whether Karvy has a net worth or money available to do that or not. And based on that, they will take action. What action they will take, I do not know, but it can amount to anything depending upon what is the quantum and what is the impact.
Anuj, if the investor is cautious and he wants to shift his securities to another DP, what is the process to follow so that he can move his securities to another DP without any issues?
See, the process is very simple. He either needs to open a new depository account with another depository participant, or if he already has an existing account, then he merely has to approach Karvy, being his depository participant, with the requisite forms and with the requisite application, and the stock would be transferred. And even in the interim order, the regulator has made it very clear that the depositories will facilitate investors to move their stocks for clients who approach Karvy as a depository participant. So shifting of stocks is not a very big problem.
Days can it take, Anuj?
Sorry?
How many days does it take to fulfill this process of shifting the DP?
Not even 1 day. If his account is up and ready, not even 1 day.
Okay.
And about money, if they have client money lying in there and their positions, if they want to move it to another broker, how much time and does it take for that?
See, now shifting of money, there are two aspects to it. Now there is simply a credit line to the client's ledger account without his having any open position. It is very simple. He has to request a payout from the intermediary. As of now, we don't know what is the position of the intermediary, whether he is in a position to make the payment or not. Because unfortunately, there were complaints from clients who were saying that the intermediary was not able to make the payouts that were due to them. So that is really something that we won't be able to comment on. Normal process is, if there is a client, if there's a credit to the client's account and there is no position, he simply has to request for a payout, and the intermediary is supposed to give out the payout either the same day or the very next day.
What about if he has open positions and he has money in the margin account?
Now see, again this situation gets a little more one step ahead, that if he has open positions, if he has money, then he has to either transfer his positions to another intermediary by opening another trading account, but then he will have to find out that what is the position of the intermediary in returning is. He'll have to square off his open positions at this intermediary and create new positions at another intermediary. But that will again all depend on the fact whether Karvy is in a position to make payment to the existing investor out of his free money or not.
And again, so it's Mr. Gupta, so it is basically a case-to-case issue here. How will investor come to know that, if I want to take a payout or if I want to transfer my open positions, whether I will be able to do so, because it's all at the disposal of Karvy, whether Karvy has the ability to do so or not.
Anuj, the issue is very simple. It is one-to-one case. I have a bank account. I have to approach my bank and say that I have to transfer this money. It cannot be done on a collective basis. So like a bank account, you see what is your balance in bank account or what is there in your security account. You have to take one-to-one action. The client can always approach Karvy and find out what is there in their bank account or what is there in their securities account, and check with their own record whether this account reflects true position or not. They will certainly know that whether any security has been misappropriated or not.
So it doesn't, my understanding is that the regulations says that the investor protection fund comes in only when the exchange declares one of the members, broker members, as a defaulter, or or he has ceased his operations.
Yeah.
Will the investor be able to approach investor protection fund if?
As you have yourself answered, it will not be possible till such time the broker is declared defaulter.
So till the time that happens, the investor will have to either wait and watch till the regulator comes out with a notice, or exchange first declares the investor a defaulter.
See, again, I would say everything will depend upon what is coming out of the forensic audit report, and after that a balance sheet will have to be drawn, that what is the real position and what is the shortfall, what is the hole. And that depends upon that. And if it is really found that the Karvy has done misappropriation and all other things, then certainly a regulatory action will follow.
Mr. Gupta, this could be a little far-fetched, but according to you, since power of attorney here was misused by Karvy, and looking at this case now, do you think regulator going ahead could not allow brokers to take this sort of power of attorney from its clients? Of course, it's hypothetical, because this sort of power of attorney also allows the broker to execute trades on behalf of their clients.
See, please understand, SEBI has been taking care of power of attorney and everything from time to time and very effectively. The issue is that you cannot help a person who is sleeping. If you have signed a power of attorney and you are not watching what transactions have been done, then there is going to be a problem all the time.
Okay, and does this current reason of course, again, I'm reiterating, it's an interim order here. What are the criterias where a regulator can go ahead and declare a trading member as default, or according to you, there can be one option also, they can just take away the clearing membership and let Karvy only be the trading member?
See, it is very difficult for me to list out everything, because it keeps on changing from time to time. So I will not be able to tell you what will happen and when will happen and what is the procedure, because I am not conversant with this on day-to-day basis.
Okay, Mr. Gupta and Anuj, we leave it at that note. Appreciate both of you joining us today and giving that clarification, which could, in a way, Sajid, allay some of the concerns of 2.4 lakh clients of Karvy.
That's true, you know, but it also, as Mr. Gupta said, you need to know how much is the capacity of Karvy to pay out to all its clients if they want to move out today, and what is the kind of open positions which they are sitting on for existing clients. So the entire issues came to fore because some of the clients started complaining that the payout did not happen and they didn't get the money, and SEBI had to intervene. At last week's press conference, SEBI did say that they have intervened and some of the clients have got the money, but there still is a issue which is there, and NSA's interim report doesn't suggest that this issue is going to get resolved very soon, because it's too much of money involved in it, and a pool account is supposed to be much bigger.
So this could be a long drawn process.
So to be fair, Karvy still continues to give a statement that it hasn't defaulted on any of the clients, but the money involved is too much.
Okay. All right. On that note, we will wrap it up here on this special edition of the covering of Karvy case with our experts. Thanks for watching.